bringing complaints under Title VI don't work anymore because of a Supreme Court case called Sandoval. And that was all about driver's licenses in Spanish in Alabama. The Supreme Court there said, no longer can you rely on the regulations and the effects tests affecting those cases. You had to prove intent under Title VI. And in fact, it left the loophole that the only way you can use regulations in challenging the acts of the school district in terms of equal educational opportunity is if the complaint is brought by the Office for Civil Rights and Department of Justice. So that individual plaintiffs out here, private suits, cannot rely on the effects test but must prove intent, which really changes the scene completely. There is a loophole still left with the Equal Educational Opportunities Act of 1974. It's not yet resolved whether under Flores you can still use effects or whether you have to use intent, but the door is still a little ajar, hasn't been shut yet. So that's basically what I want to talk about.
Well, thanks, Alan. You gave quite a roadmap, and also you reminded me that I didn't have very good manners myself I didn't have very good manners in terms of thanking Estelle Rogers for inviting me to be on this panel. And one other thing I wanted to mention, John Payton was originally supposed to be moderating this panel. I'm filling in for him, and I really, it's an honor to be filling in for him. I'm not really an adequate substitute, and you know, he was a giant in this field, in the field of civil rights and in education. Is perhaps his greatest legacy, and it really is the idea for this whole conference is consistent with what John believed in and fought for in his many years in the trenches. And with that, I want to introduce Art Coleman. Alan was talking about the Office of Civil Rights at the Department of Education. Art knows something about that. He was there for about 7 years during the Clinton administration. He was a deputy assistant secretary. He was also a senior policy advisor. Art's a partner at the law firm Nelson Mullins, and he also is, I guess, the co-founder or the founder of Education Council.
That's right.
And I'm hoping that you're going to talk a little bit about what Education Council does. So Art is both litigated and he's involved in issues like guidance, policy, and that experience is going to help inform this panel.
Okay. Thanks, John. Good afternoon, everyone. So I'll start with a mild slap on the wrist. The fact that you said Nelson Mullins and not Nelson Mullins Riley in Scarborough means my senior partner, former Secretary of Education, Dick Riley, would not be happy. He's also got issues with the way the firm is branding itself, but that's a whole other story. Let me give you 2 minutes of background. Frankly, as the lone wolf out on the panel, I'm the recovering litigator. I blissfully do not try cases anymore, although I get involved in litigation from time to time and do some brief writing. Education Council is an affiliate of our law firm. We formed 4 years ago with an eye toward driving policy and practice in ways that conformed with federal standards and would advance meaningful education reform. And so it is an education reform entity of the law firm in which we focus on policy, strategic planning, and guidance to institutions, philanthropies, and others around the country. And so I come at this, and instead of giving you sort of the preview of what I may focus on in the context of some of the sub-issues, I'm going to just share a sort of worldview with you coming from both my litigation days, my federal policy and enforcement days, and now my consulting role. And I guess the first thing I would say in the context of, as I understand, the central objective of this panel is to talk about litigation and how to achieve systemic reform with respect to litigation, is to bear homage to my two favorite words out of Ruder versus Bollinger, context matters. That we're not operating in the courtroom in isolation. It is in the context of district policy, state policy, federal policy, and there are arms and avenues on which we can find support just as we drive what we are trying to learn. One of my very strongly held worldviews when I was with the federal government was that federal policy should not be a top-down matter of design, but it should be bottom-up. It should be grounded in the reality of what is going on in the classroom and with schools around the country. And to that end, sometimes we think of litigation as litigation. Well, what are the lessons out of that litigation that should be informing, independent of the litigation, the sort of the policy spheres and the way that others understand that? So the context matters here, and the prospects for support with, as you mentioned, the Office of Civil Rights or Department of Justice, where OCR, you may not know, handles something in excess of 6,000 complaints of discrimination a year that don't get high visibility most often because they tend to be resolved quietly. There are certainly some that hit the press. Those were the ones that ended up on my desk after they hit the press, but that's also another story. The second point I would make is I don't think we can talk any of these issues as distinct as they may be from each other today without acknowledging there is an overarching policy direction in terms of education from top to bottom around accountability, around a demand, a renewed and a heightened sense of results. And so I have no conversation on any facet of education without actually talking about for what outcomes, how do you know, and what is it going to cost? And that is not a Republican, Democrat thing. It is a common thematic in a time of both tight budgets and heightened expectations as we are in an era of rapidly changing global economies and demographics in this country. So it's a sort of shifting sands, but a clear, and we may get into some of this, even in the context of No Child Left Behind, which, and I'm happy to talk about this, I'll be politically incorrect. On balance, I think it was a very good law. I think it was badly implemented in lots of ways, but the way it recast the education conversation was a net positive for the kids we are talking about today, and I have some views on that. And I guess the last thing I would say is there's a sort of interesting, when you look at the actual cases in court, where you don't often get the results you want. It's at times, in the one case I'll talk about in some detail is the school funding case out of South Carolina, where the court was quite reticent to step on the toes of the state legislature, quite expressly saying we don't want to become the super school board. Kudos to them. I don't want a court becoming the super school board either. But how you navigate that line and where is important, because on the one hand, where we're saying, court, you must intervene, on the other hand, in some race cases, we're saying, court, back off, we've got this. Academic freedom and deference is ours, don't interfere where you don't need to interfere. And so there is some interesting underlying tension in segments of cases that go to these issues.
Thanks, Art. And then finally, Marie Sneed, who's a partner at Hogan Lovells in Washington, D.C. Marie is one of, she's going to be on the short list when you have a school district that is involved in a major case or a major difficult issue that it has to work out. She represents districts all over the country. She litigates cases all over the country, and as I referenced before, was involved or filed amicus briefs in two of the Supreme Court cases that we're going to be talking about. Interestingly enough, Marie not only has been involved in schools work as a lawyer, but also as an administrator, including a principal in Montgomery County, Maryland. Marie?
Thank you very much. So my background, I come with that background that I spent 10 years as an educator. I was a teacher, principal, and central office administrator. I am a product of at least gender affirmative action. I was the third female secondary school principal in Montgomery County because they didn't think girls could run secondary schools. But someone gave me that opportunity, and I guess probably thought I could break up a fight, which I did many stupidly in trying to show that I could do that. I have seen myself throughout my career as being a civil rights advocate, even though I do represent school districts, and many of you may say who don't represent school districts, how can you do that? But I'm sure, like Kay and others in the room, we see ourselves as being able to do that. I did my dissertation, I have a doctorate in education, on changing racial attitudes, so it's a passion of mine for a very long time. I do both litigate and I do counseling, so I have the luxury of doing both, and I think it's helpful. I think it has helped me be a better, because I litigate, it's helped me be a better counselor, and because I counsel, I'm a better litigator, and I've had, as many of you, if you represent school boards, have to learn how to count votes in order to get what you need to get done, which is also challenging. I'm the recipient, typically, of litigation, right? Because it's usually my clients who get sued, and so, well, I have sued some government entities, and I'll give an example or two. I'm typically the recipient of that. What I've tried to do, and what we've tried to do in our practice, is try to think about how do we use those court orders, the consent decrees, the remedies that have been ordered by the court, how do we use those to bring about change? And so it's not just a matter of going through the motions of implementing a court order, but how do we really bring about change? And so an example would be, we represented the Baltimore City Public Schools in their 26-year consent decree Von G case, and we did some work with them probably about 5 years into their consent decree, and then didn't represent them for a while, and they came back and asked, about 5 years before the case was over, if I would work with them again, which I agreed to do that. And so what I tried to do with them, with their leadership, is come up with strategies that would be good for kids. And one of the strategies, I don't know where you guys, and you're for any districts or states, that they use a stat process. So like this afternoon, every Friday afternoon, they look at attendance data for all of their schools. And they look at discipline data for all of their schools. And say, what trends have we seen over the last week? What do we need to do next? And you can see how that fits in the legal process. They have a similar process called special ed stat, which meets every 2 weeks. Again, the data by school, by network, what some people call area. Do we have to send a SWAT team in? What do we have to do? So what I like to do is work with school districts to use those kinds of things to accomplish what you're required to do under court order. Many of you know I've represented many school districts that have been under a court order, and after the Dow case came down, the Oklahoma City case came down, many of us were not happy with the results, as you'll recall, because we knew Oklahoma City hadn't done what it needed to do. I particularly knew it. My family lived in Norman, Oklahoma, which is just about 17 miles south. I knew who Bus Bohannon was. That was the judge's nickname. And you know, we knew they hadn't done the work they needed to do. So what I tried to do even after that decision, as you'll recall, the court had 3 standards. It said you have to show, have they complied? Have you eliminated the vestige? And can the board show its good faith? So in my work and in our work, what we've tried to do, if a district said, well, we think we might want to become unitary, that we've been very affirmative and thoughtful and said, well, we're going to have to do a unitary status analysis or audit and see where you are. And so that accomplishes 2 things. 1, you're going to find some holes. And 2, to the extent you're going to file a motion down the road, you're going to put together that evidence. I'm going to Duval County next week, which is a school district I worked with for 5 or 6 years, before they filed a motion for unitary status. So they were very thoughtful about what they did. And so how I see myself is taking those tools or making into tools the court orders to accomplish a purpose that is good for kids. It's the best you can do when you get an order which says, well, these these